My name is Doobay and I'm a consultant with Peters & Peters Solicitors in London, and I'm going to be speaking to you about three framework decisions. The first is the European Arrest Warrant Framework Decision. The second is a framework decision which deals with trials in absence, and the third is a framework decision which deals with conflicts of jurisdiction. So turning to the first of these, the European Arrest Warrant Framework Decision, it's perhaps worth mentioning the background to this decision because it will put into context what it's aiming to do. It is the first of the mutual recognition measures. Now, mutual recognition was a concept which was endorsed at the Council meeting in Tampere, where the EU decided that it would go forward in its international cooperation in criminal justice matters by using the principle of mutual recognition. So the judicial act of one member state would be recognised and enforced by another member state. That was the principle, and it was founded upon the concept that there was equivalence between the criminal justice systems of all of the EU member states, and therefore there wasn't any need to question judicial acts taken in another member state. So the first measure was the European Arrest Warrant, and the framework decision was enacted in 2002. Initially there had been some debate and some political controversy over the idea of the European Arrest Warrant, but that was put to one side very quickly after the terrorist attacks of September the 11th. The system is predicated on the execution of a warrant issued by another member state, and therefore the framework decision uses the term surrender rather than extradition, because the EU had in mind to try and move away from the extradition system, which was seen as involving political input and also was seen as a lengthy and time-consuming process, potentially with some examination of the facts. So the EU wanted to move away from that system and towards the straightforward system of surrender, where a judicial act issued by one member state, i.e. European Arrest Warrant, was simply received and enforced by another member state. The framework decision had to be implemented by the 1st of January 2004, and most member states managed that, although there were some who were not able to comply with the deadline. But now all member states have in fact implemented the framework decision in their domestic legislation. And it's been in operation now for a number of years, and this has allowed the Commission to produce evaluation reports, and it's worth having a look at these to see what issues the Commission has thrown up in terms of the failure of some member states to implement the framework decision correctly according to the Commission, and also the practical problems that have been revealed by the operation of the warrant. And I'll come back to some of those a bit later on when I look at defence issues which practitioners may need to be alive to. So turning to the framework decision itself, what is it? Article 1 states that a judicial decision issued by one member state, i.e. the issuing member state, with a view to the arrest and surrender of a requested person by another member state, i.e. the executing member state, for the purposes of a criminal prosecution or executing a custodial sentence or detention order, can form the subject of a European arrest warrant. The European arrest warrant is simply a form which the pro forma is annexed to the framework decision, and so long as the issuing member state correctly fills that out, then that should allow them to make their request for surrender. It's hoped that this mutual recognition measure will eliminate the delays and the complexity of the previous systems, and if statistics are anything to go by, then it's certainly achieved a reduction in delay, because the framework decision itself sets out timescales which the executing member state is supposed to adhere to, and the Commission judges executing member states on their ability to comply with those timescales. And certainly what is clear from the Commission's reports is that the surrender system brought about by the European Arrest Warrant is significantly increasing the speed with which these requests are dealt with in EU member states. So what can be covered by a European Arrest Warrant? Article 2 specifies that an EAW may be issued by acts which are punishable by a custodial sentence or a detention order of at least 12 months. So that sets a minimum threshold for the seriousness of offences which can be dealt with by the European Arrest Warrant. That's for accusation cases. Now, in cases where there has already been a conviction, the requirement is that there is a detention order or other sentence passed of at least 4 months. So again, there is a minimum threshold of length of sentence required. There is no need for the double criminality verification where a person is accused of one of a list of categories of offences Now, this was a significant innovation when the European Arrest Warrant Framework Decision was enacted, because traditionally for extradition cases there had been a need for the conduct which underlies a request to give rise to a criminal offence both in the issuing member state and also in the executing member state. But at an EU level it was decided there were certain categories of offences which were either so serious or which were so widespread, i.e. there was so widespread an acceptance of them, that there would be no need to have the double criminality requirement. And there were these 32 categories of offences which were agreed and which form part of the European Arrest Warrant. As I've said, the content and form of the European Arrest Warrant is both dealt with in Article 8 of the Framework Decision and also is shown in the pro forma, which is attached as an annex to the Framework Decision. The transmission of European Arrest Warrants can happen either directly from one judicial authority to another, or more normally they will be circulated by the Schengen Information System. And this allows for the easy uploading and transmission of these SIS alerts to all the EU member states. That the UK isn't currently a member of the Schengen Information System, but it has agreed that via the Schengen Information System 2 it will have interoperability with this system of alerts, and so therefore in the next couple of years it's expected the UK will be part of the Schengen Information System in terms of the circulation of alerts for European arrest warrants. So what are the rights of the arrested person when they are subject to the European arrest warrant? They have the right to know the contents of the EAW, to be informed of the possibility to consent to surrender, and that's a significant innovation because under the previous extradition systems it was not necessarily the case that a person would either be told about the right to consent to surrender or that the domestic law of the country concerned would have a consent procedure within its legislation. So the person must be told about the possibility to consent to surrender, and therefore they can move quickly back to the country which has issued the request, and they can deal with either the prosecution or they can serve the sentence which has been imposed. The other thing which the person has is the right to be heard by the executing judicial authority. So if they do not accept that they should be sent back to the country which has issued the European arrest warrant, then they should have the right to be heard and for their objections to be determined. So what are the grounds? There are a number of grounds for the mandatory non-execution of a European arrest warrant, and Article 3 deals with these. I'm just going to give you some examples because you can see the full grounds within the framework decision. So one of the examples is if there is an amnesty in the requested member state, or if the person has been tried in respect of the same fact. So this is essentially an encapsulation of the double jeopardy bar or the nebis in idem rule. Article 4 deals with optional grounds for non-execution of the European arrest warrant, and each member state will have taken a choice as to whether or not it has put into its domestic legislation one or more of these optional grounds. Again, just by way of example, there can be a bar, which is an optional bar, if the person is being prosecuted in the executing member state in respect of the same acts, or if the judicial authorities in the executing member state have decided not to prosecute, or have halted proceedings, or if there has been a final decision in respect of the same acts. So there are a number of optional grounds for non-execution, and you should look at the domestic legislation in each EU member state to see which optional grounds they've chosen to implement. There is then a process which is laid down in the framework decision for the surrender decision, and also time limits which the executing member state is exhorted to try and meet. So where a person when a requested person consents to surrender, the final decision on the execution of the EAW must be taken within 10 days of their consent. In any other case, the final decision must be taken within 60 days of the arrest of the requested person. So that's the aim, is to try and speed up the process, and although there is an ability for the executing authority to request an extension of 30 days on top of the 60, the idea is that in almost every case it would be possible to deal with the European arrest warrant within 60 days. So that's a very brief outline of the process and the substance of the European arrest warrant as laid out in the European arrest warrant framework decision. I'm now going to look at some of the issues which have been raised by the operation of this, and therefore some of the issues which a defence practitioner may need to look at when addressing a European arrest warrant case. The first of these issues is the case of proportionality. So there are a number of countries who have issued a large number of European arrest warrants, and they appear to have done so without looking at the facts of any individual case to decide whether it's warranted to issue a European arrest warrant. So in some cases the requests are made for offences which are either very old or might be considered trivial or more minor offences. The Commission has recognised that this may be firstly causing a great deal of strain on the system for those executing member states who have to deal with these large number of requests, and also maybe potentially bringing the system into disrepute, as the public are certainly not seeing the system being used to deal with serious offences which have been committed more recently, and may be questioning the validity for the mutual recognition system. So the first response of the Commission has been to try and introduce a proportionality test by way of the European Arrest Warrant Handbook, which issuing member states are advised to take account of, and this sets out a number of factors they should consider before deciding to issue a European arrest warrant. So the relevant factors are the seriousness of the offence, whether there is a reasonable chance of conviction, the harm caused to the victim or the community, the likely sentence in an accusation case, the previous convictions of the requested person, the age of the requested person, the views of the victim, and any reasonably alternative options for the issuing member state. Now, there may be a number of these. So, for example, they may be able to proceed by way of summons, or they may be able to use other framework decisions which allow them to transfer sentences or fines to be executed by other member states. So they should go through this checklist to work out whether it is really proportionate to issue a European arrest warrant before taking the very intrusive and potentially harmful step for an individual of removing them from the country they're in order to either try them or have them returned to serve a sentence. The measures which I've mentioned, which issuing member states should consider, I'm going to go into slightly more detail about those. So I mentioned the possibility of recognising and enforcing fines by member states. There is also the possibility of releasing people on bail using the European Supervision Order, which will allow a person to be bailed to a different member state with conditions which can be enforced by the member state where they will reside until they're going to be tried. There is a possibility of serving summons, which can be done through the normal system of mutual assistance, which takes place through normally between EU member states through the Council of Europe Convention on Mutual Legal Assistance. So the other big issue which has been thrown up by the European arrest warrant is the issue of human rights, because obviously all of the member states of the European Union are parties to the European Convention on Human Rights, and part of the foundation stone for the mutual recognition system is the belief that all of the member states therefore adequately protect and uphold human rights. Of course, if one looks at the case law before Strasbourg, it's clear that every member state doesn't on occasion indeed uphold human rights as they're supposed to, and that there are significant and sometimes frequent violations by member states. So the question is, how do you deal with that in the context of a system which is supposed to be simply a recognition of a judicial decision by another member state? In the United Kingdom, there's been some tension between the need to try and ensure that human rights are not violated as part of the surrender system and this mutual recognition principle. The Commission itself, whilst affirming that there should be no violations of human rights, is also struggling with how to ensure that this doesn't lead to a very detailed examination for every case as to whether or not there might be a violation of human rights, for example, because of the prison conditions in various member states, whether these conditions might on occasion fall below the threshold of Article 3, which provides protection against inhuman, degrading and cruel treatment. So these issues are causing some concern amongst both member states, the public, judiciary and the Commission, but there is an attempt to deal with them. The Commission, particularly in terms of prison conditions and pre-trial detention, has published a green paper, and they're looking for ways in which to raise the standards in EU member states, of both their prison conditions and also to reduce the time in pre-trial detention, which obviously is part of the right to have trial within a reasonable time within Article 6. How successful both this measure and these measures and the attempt to introduce proportionality test in the issuing member state will be remains to be seen, but obviously the Commission may decide to legislate at some point and to amend the European Arrest Warrant Framework Decision if it feels that significant enough progress isn't being made in dealing with those issues. So the European Arrest Warrant Framework Decision is the first of the mutual recognition measures and certainly is seen by the EU as the most successful of them. It's had the widest impact within the European Union, and whilst there are certainly some controversies which are still existing around its operation, it looks like it will continue to have the most impact for citizens within the European Union for some time to come.